One of them wanted to be the security guy. He claimed he was a security guy.
Welcome to a non-compliant version of Security Guy.
I'm always compliant.
You are never compliant. What are you talking about? A non-compliant version of Security Guy Radio with your host, Chuck. Don't do a background check on the Herald.
Oh, no. I can tell you.
And Paul Tally-ho.
Tally-ho,
Tally-ho,
Bristow.
Bristow. Yes, we're doing another background check show. Is this microphone on, Mr. Brian, the engineer?
I can hear you.
We have technical difficulties again. All right. Yeah, we're going to do backgrounds again today. But really kind of a follow-up from our show we did in, when was that? December?
A while back,
Yeah. So, background checks, I've been doing them for a long time. And you were doing them at the studios, hiring people and stuff. The bottom line is most people have it all wrong.
Wasn't doing enough.
Well, that's true, apparently.
Yeah.
Well, you hired
Because we
me.
hired you. Yeah,
That's
exactly.
Right. Can I have a drum roll?
I took somebody's
drum snare,
word
please?
for that.
That's right. So, today we have our returning guest, Mr. Rafael Jorge of RGI Investigations. Welcome, Mr. Rafael.
Thank you. Glad to be back.
So, how long have you been licensed?
Oh, my goodness.
Long time,
As
right?
a private investigator in California since 1988.
Yeah.
And in Arizona since 2004.
That's when I got my license in 88. That's a long time.
Yeah, it's been a long time. Been doing backgrounds since about 1990, so that's 24 years. We just celebrated our 24th year anniversary, so
let's define.
That's a long time.
Let's define what a background check is for people. It's not going to phonedetective.com, which is a great little service. They have archive records, right? You push a button and somebody's name
Right.
comes up and finds stuff.
Right.
It's not really.
I'm looking at instant backgrounds here
Yeah, there's all kinds
for
of them out there now.
$25.
Well, remember back in the day, I think it was.
Well, what's interesting is they were just involved in a non-compliance
Oh, really?
lawsuit, so that's
so
funny that you just brought them up.
So I should ban this from my... little
Yeah,
iPad.
probably not what you should be using when it comes to employment background searches.
So what everybody needs to realize about background checks is you have different types. You have just this kind of public record, take a check. It's not used to do anything to somebody. It's not used for derogatory, means or to deny employment or something like that. And then there's a real employment compliant background. So we're going to talk about both today. So basically, if you want to go find some background on people, the best source is what now? It's Google.
Well,
I mean,
true,
or let me say Bing as well. And you
well,
say Bing for my show.
those are really good research and investigative tools.
That's right. Research is right.
But they're not really used for employment purpose.
Not for employment. I'm just saying
Right.
if you want to find something
Sure,
on somebody, it's
sure.
almost
If you
all
just
on
want
the
to be
internet.
your own little mom PI, I guess, and you want to find something out about your neighbor, Google's a great place to go.
Right.
You
but
know,
people mistake that for background checking.
That's
It is
right.
not.
That's right. A lot of employers, unfortunately, may use something like that, or like this organization you just mentioned, to conduct their pre-employment background checks, and that is not going to be compliant. One of the biggest things that I see in California is very unique in its own way because it has certain provisions and guidelines that employers need to follow.
It is different than the rest of the country. Really.
It's totally different. You have the federal law, and then you've got California law, and you're most likely to get sued by a California attorney for a California violation than you will by the federal.
Okay.
It's just the way it is. Now, I don't know if that has to do with the fact that we have a heck of a lot more attorneys in California than anywhere else in the United States, but a true background search to be conducted for employment purpose should be done through a consumer reporting agency.
Define that for people. What's that mean?
A consumer reporting agency is an organization that conducts background investigation for employment purposes and charges a fee for that transaction.
So,
Okay?
what example? Credit reporting bureaus are an obvious example of that. But
Yeah.
what's a non-obvious example? What else could be that sort of institute?
Well, RGI is a consumer reporting agency.
You
know,
are.
We
Okay.
conduct background investigations for employers. Employers hire us to conduct background searches, whether they be security firms or ABC Pharmacy. We do the backgrounds. We then become a consumer reporting agency.
So
and
it's
there's
not
certain
about
guidelines.
it's not about you that holds the original data on somebody.
That's right.
Because I thought it used to be that TRW back in the day was a consumer reporting agency because they had the data
Right.
and you
Right.
went to go get it from them. But you're
Right.
now also defined as a consumer reporting agency.
Well, a lot of things that what I'm going to talk about today is mainly in the realm of criminal background searches being conducted for employment purpose. Okay, and that's one of the public entities that we access, is how to go to the courthouses and obtain the most current and up-to-date information on criminal records.
What's the difference legally from an employer conducting their own background checks and using a consumer reporting agency? Because
Well,
there is a difference.
There
right?
is a difference, yeah, and a lot of employers do choose to do their own background searches. Now, there's certain things that they have to still adhere to under the California law, but there's certain things that they're not as open and exposure, I should say. They're not as exposed to the FCRA guidelines. I always tell employers, you're better off passing that on to a consumer reporting agency, that is what they do best, because that way you're able to pass on that liability and to make sure that you are state and federal compliant.
And FCRA is Fair Credit Reporting Act.
The Fair Credit
For
Reporting Act.
My novice listeners.
Which is
Yes.
actually
That's
governed and enforced by the FTC, the Federal Trade Commission.
Okay.
And there are a lot of things going on right now in the entire country, especially in California, when it comes to FTC violations and background non-compliance issues.
There are a lot of employers that I run into believe mistakenly, and perhaps you can get into it a little bit more, that if they do their own backgrounds, i.e. through Google and all the rest of the stuff, they don't actually come under the FCRA at that
Well,
point.
they don't in certain instances, but however, if they're searching for criminal records, any information that is found on any database, whether it be Google or Instant Checkmate or any of these other databases that are out there, that information needs to be verified at the most current and available place, which would be obviously the courthouse.
The court. It's always the court.
Okay. And if you plan to take adverse action based on that information that you found, you need to verify that information before it's reported.
And if an employer uses any database, that's considered a third party, right?
That's
So then
well,
comes under
it's
the
considered a
FCRA.
third party, but it also needs to be verified before they take adverse action.
Yeah.
And that's where a lot of companies get into that problem, is they'll find something. As a matter of fact, there's a class action lawsuit right now going on in New York. The individual's name was Kevin Jones. It's out there in public records. And Mr. Jones was denied a job working at a hotel. Well, the information was reported by a consumer reporting agency that Mr. Jones had a criminal conviction, and it was found in a database. Well, that information was never clearly verified to be that exact Mr. Jones. Coincidentally, it turned out to be a different Mr. Jones, and that Mr. Jones did not get employed.
I would imagine there's a lot of Mr. Jones, right?
You know, the fact that
So
they
who-
found it on a database and
Yeah.
didn't verify the information before they reported
Yeah.
it, that's where the problem comes in.
Well, I guess there's one today just broke with Experian, correct? Did you see that in the news today?
Oh, no, I did not see that one.
Experian I guess, are being hit for some false information on some of their database information.
That caper
So-
in New York, was that the employer doing the background check and finding a quasi public record that they said was it, or
Well,
did
the
they use a
employ-
consumer reporting
Yeah,
agency?
the employer had subbed out to a consumer reporting agency. It's a large hotel chain. And this gentleman went out and,
Okay,
saw.
so who do they hire? Who
They-
did the hotel hire? What big big
Well,
box company?
they hired Sterling Backgrounds.
Sterling?
Yeah, and
Okay.
it's actually on public records, so there's nothing I'm divulging that it's confidential, but it's actually on public records. And basically what they did is they apparently, from my understanding, is they did not verify the information before it was reported to the hotel chain.
So when I was running some guard companies, I had the same issue for years. And you talk to these big box companies and you say, can you explain to me how you're compliant? Well, we use the database from New Jersey and we use the database from New York, and that's the official court database. Therefore, it's an official record. And I go, oh, it's not the same as going down to court. And they think, that's problematic. And I've always known that if you go down to court and look at it in the file, then that's really the most recent data. Am I right?
True, but there are certain states that the information that is being obtained and provided by the court is the most current information available.
Here's why it's not. I disagree with you strongly on that. So you get convicted on Tuesday, and the clerk takes the paperwork, puts it in the basket, and Susie, the clerk, was supposed to go pick it up. She was out partying last night. She didn't make it to work. She forgot about it. It sits in the basket. Doesn't get stuck in the database until what? A week later, and I do an online check, and I find that, guess what? I'm going to hire you because you're totally clean. There's no record of you on
Well,
online. from the official court record, right?
From the official court record.
And then it turns out that you're convicted of rape, and now I got a problem because I hired you.
But you would find that there was a pending adjudication on that possible rape case. So there's a difference between a filing date and a conviction date. So if the filing date is on this general index, and the index says that there is pending adjudication on it, you can report a pending adjudication.
All right, that
now you
seems
can
like a contradiction to me, because it's just like, remember we were cops, you can't run a rap sheet on somebody unless you're a police officer. Rap sheet meaning here's a record of your arrests, not convictions, just arrests. You can't use it against somebody. Why is this difference? Distinguish that.
It's a pending adjudication. That means the individual has a appearing court date for that possible conviction. And you can report a pending case under the Fair Credit Reporting Act.
Can't use it against them, though.
You can't use it against them, but you have to follow up on the conviction date at a later date.
All right. So I hire you to do this. You find a pending, what'd you call it again?
Pending adjudication.
Pending adjudication on me.
All right.
You're going to call Paul, the employer, and say, Paul, Chuck's got this pending adjudication.
Right.
Here's my advice. Let's wait and see what happens.
That's
or
right.
Or does Paul say, I'm not waiting to see what happens. I'm going to pass on this guy and hire somebody else?
Well, that's the problem, because then the due diligence process hasn't been completed, and you were denied employment because of that negligent due diligence. In the state of California, you would definitely have an issue with that, because you have to. You can only report. You can only use convicted records against a prospective employee. So the fact that you made already took adverse action, okay, and you made an adverse decision based on that information, that's wrong. You need to wait to see what that conviction information is and whether or not that conviction information is relevant.
And the employer would have to tell them.
That's right.
Why.
What you do is you send out a pre-adverse action letter and telling them, Mr. Harold, we found a possible criminal record that may prohibit you from being employed in our organization. Pending this trial that you have coming up on XYZ date, a further decision can be made on your employment.
So I was doing background checks for many years, working for, let's just say, some other companies. And every year we ran the same background check for a special event, because every year the same people came back to the special event. And every year the people got cleared and everything was fine. And then one year we switched to something more specific like you're talking about, where supposedly was a better compliant sort of service. And the same people that had been cleared for 3-4 years before, who didn't have a record, all of a sudden popped up with records in the same time period, by the way. So tell me how that happened.
I couldn't tell you how that happened, obviously, other than the vendor that organization
probably using a
used
database.
Was different. Maybe they used a database. I don't know exactly the circumstances, but what it sounds like to me, if it's there today, it should have been there yesterday.
Unless they're using a non-compliant database, an archive that's old.
That's right.
To my point of Susie the clerk not putting the record in the database, it could be 2-3 months. Who knows what court's reporting what online.
Now, you look at the average databases out there, anywhere database. Now, we're talking third-party databases that are compiled information from courthouses that these companies then resell. And some of these databases could be as old as 30 days. Some could be as old as 6 months.
6 months.
6 months.
Wow.
Some of the databases out there, because the county itself does not report or provide their records to these third parties, okay, to compile this data 6 months from now.
Now, what about where somebody has had their record expunged, and it's not taken off of that database, and the employer gets that information and then doesn't hire somebody because of that?
Right. That's
non-expunged.
That's a total violation. You cannot use expunged records against an individual, okay, for employment purpose.
Now, is the employer liable at that point?
Sure, of course.
Okay.
Yeah. I mean, basically, you discriminate against that person because of a conviction that was expunged. Today, in the last 3 years, I have seen more and more petitions for what's called the 1203.4 expungement.
Yes, 1203.4. Remember that.
Okay. So I'm seeing more of these things taking place because more employers are doing backgrounds. Especially in the state of California. Okay. We specialize in the West Coast, but our core competency really is backgrounds in California. And when you look at a lot of expungements going on, if a consumer reporting agency reports an expunged case to an employer, that consumer reporting agency is also going to be on the hook for some violations.
Oh, they don't They're not obligated to report it? Or
No.
they should not report it?
No, they should not report it.
Oh, interesting.
They should not. It is still available in public records, though. But they should not report it.
Okay, so here's the dilemma. I Google you. I find this code section in a case in the newspaper that says I got convicted of something, and I look up the code and it's expunged. But I found it in Google. I got a problem. I'm not going to hire you because I don't care if it was expunged. You still did the deed.
Yeah.
You did
California will have a whole different
You
position on
can't
that.
say you didn't do it. You can say you didn't convict
Oh,
it,
of
but you can't
course.
say you didn't do it.
Of course.
There's the music for a break. We'll be back in a minute on Security Guy Radio. That's securityguyradio.com. Follow us on Facebook, Twitter, YouTube, and LinkedIn. Back in a minute. Welcome back to Security Guy Radio. That's securityguyradio.com. Follow us on Facebook, Twitter, LinkedIn, and YouTube. Please follow us. Please. I told you about the demographics a couple weeks ago, right? Because you missed our last show with Microsoft. 4,000 listeners a week.
Yeah.
Verified.
Yeah.
Twitter's up to 10,000. What do you call
Yeah, no,
Twitters?
it's good.
Tweeters? I don't know what they are.
Tweeters?
Birdies?
Twits.
Twits.
I don't think so.
I don't
they're
think twits is the right word.
I think they're tweeters.
Followers.
Followers, yes.
Followers,
Well,
there
you know what?
Followers.
That sounds a little too cultish to be followers.
No,
I'm
I think
sure like that.
followers is better than
Twits?
tweeters
All
or
right.
tweets.
So 10,000 there, and what did I say we had on Facebook? Our Facebook page is about 12,000.
Yeah.
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 So we're getting
It's
out
good.
there. Getting
Great.
out there.
That's good to hear.
Very good to hear. So we're with Mr. Rafael of RJI Investigations, licensed private investigator since 1988, I think it was.
88.
88. And we're talking about background checks and really compliance and how most people are out of compliance. So let's just do a quick review so my novice listeners can understand a little bit about what's going on. We're talking about background checks, talking about background checks for employment reasons.
Correct.
We're also talking about background checks of a criminal background
Nature.
purpose.
That's
Yeah,
right.
I mean, because if I do a background check on you and I Google you and you come up as a guy that does parties on Facebook, that's maybe going to influence my hiring. But really, if you got a criminal conviction, that's a problem. And that's where we get in trouble with lawsuits and people suing us and all that kind of things. If we don't do it right, especially in California, it's going to be a major problem.
That's right.
As it should be, because as we talked about the case in New York, if I'm doing a background check and I get it wrong and I take away this guy's livelihood, that's just not right.
Yeah.
So they got to get it right. And the
correct.
best way to get it right that we're talking about earlier was that the law says the most recent record should be used, right?
The most current and
Current.
up-to-date information available should be checked for employment purposes.
And that's usually the one down at the court
And that's
inside
usually
the box.
one down at the court.
Yeah,
Right.
that's
I mean,
it.
for us, RJI, we don't do anything on databases. All of our criminal records are checked directly at the courthouse by sending an individual into that courthouse to do an index search and to verify information. If I find a possible criminal record on a Chuck Harold, for example, we're going to do everything in our power to verify two pieces of identifiers. Okay? And those two pieces of identifier are going to be either a driver's license, obviously the date of birth, because that's
Right.
the most common, name and date of birth. And I'm also going to look for any middle names that match my subject. And I'm going to look for additional identifiers like a driver's license and or a Social Security. A lot of times the Social Security is not going to be on the file,
Yeah.
but they'll be able to verify it with the court clerk at the counter. We normally take those extra steps when we're backgrounding an individual with a common name like Hernandez or Gomez or
Jones.
Fernandez or Jones or someone
Bristow.
That's
like that.
it's
Right.
quite
Or Stowe.
common.
Yeah.
So let me just distinguish this for everybody so they understand. Your company are the guys that are doing the work. They're going to the court. They're checking. The big box companies, we'll call them, the really big giant online companies, usually are hiring somebody like you
Correct.
to go out and do the work because they don't
Right.
have a staff around the United States of 3,000 employees that
Right.
go to every single courthouse. There's thousands of courthouses, right?
Yeah. It's
Right.
thousands and thousands of courthouses throughout the
So
United States.
how do the big box guys get such a hold? They go out and get investors. They do build a website, and then they just go out as a business model and hire you to actually do the work. So
In some cases, a lot of them do that, yes. A lot of the major background companies or the major consumer reporting agencies have a network of researchers throughout the country.
Right.
Whether it be an individual company like myself or individual researchers that go into that particular court and only that court for that company.
And then a lot of them just use an online record and say it's compliant, and that's where you got to be careful.
A lot of them use online services, and there have been a lot of issues with that. I'm not saying just because they're large they use online services. Again, databases are a great source of investigative tools. I think they're a tremendous source for that. However, it's information that definitely needs to be re-verified before it can be reported or before it can be put on any kind of a report that goes back to an employer who then has to make or take adverse action based on that information.
How do you find the courthouse that you have to go? To? I mean, obviously, the prospective employee isn't saying, "Well, I was arrested in Santa Monica, so go down to Santa Monica courthouse."
Well,
so how do you find those where to actually look?
All courthouses in the state of California are county-based. So if you were arrested if you were convicted, I don't want to use arrest because, remember, in the state of California, we cannot report arrest records, only conviction records. So if you happen to have a case filed against you in Santa Monica and you were convicted in Santa Monica, it doesn't matter what court I go to, I'm going to be able to obtain that information in Los Angeles County, okay, because it's county-based.
But how would you find that in the first place?
Basically, it's done, all the background searches are done by the primary residence and or any other residence that the applicant lived in for the last 7 years.
Okay.
California is a 7-year law or 7-year state. There are certain states in the United States that you can only report convictions inside a 7-year period. Other states, you can go beyond that. But California being a 7-year state, I go to the residence or the county of residence of that applicant.
Supposing Chuck had been arrested in Arizona, how would you find that? And yet he was living in Santa Monica.
I would not be able to find that unless we did either a national database search, which again, a great investigative tool. Okay,
it's like a pre-investigation, really.
It's like a pre-investigation. Yeah. It's actually a good starting point. Okay, or we run a DMV license. Okay, check, which come back and says, hey, Chuck Harold used to live in Arizona.
Oh, nationwide you can do that.
I can do that on a nationwide basis.
Right.
The nice thing about that tool is it alarms me as to the fact that he used to live in Arizona, yet he never told the employer. I'll give you.
So you can fire me for lying.
Well,
no, you can't.
You defrauded the application.
Yeah,
actually,
right.
You defrauded the application. You're going into a relationship. You're already not put in that, and that's a very common thing that criminals do. Yeah. They'll be arrested in Orange County. They'll go down to the next county, apply there, and say, well, I've only been employed and or lived in Los Angeles County for XYZ years. Well, when you do a DMV search and it comes back and says, well, he used to live in Orange County, I'm going to wonder as an investigator why you never told me you lived in Orange County. I'll tell you a story. We had one many years ago, the same situation. We ran a DMV, came back that the individual had a driver's license out of Texas, Dallas, Texas. So we have a relationship with our clients that either A, they allow us to go ahead and pursue that investigation and just bill them for it, or B, we notify them that we have found additional addresses for them that he never revealed in the application, and we get approval at that point to go investigate that case out in Dallas. Well, in this particular case, we had the relationship where we just go get it and bill him. Sure enough, the guy had, not only was he convicted in Dallas, but he had an outstanding bench warrant in Dallas. That's why he moved to California and applied in California and said, well, I've been at this particular address for the last 7 years.
Okay, so this is complicated stuff.
It could get complicated.
Could get complicated, right? If you keep it simple, but most people don't think about it that way. They think about, I'm just going to run a check and I'm home free. I'm done. I did my due diligence. My duty, right?
That's right.
So what is negligent hiring? Define it. Negligence on behalf of the employer, let's say.
Well, I'll tell you what. I just did a conference for the California Association of Licensed Investigators, and I spoke to about 60 or 80 investigators, and this is one of the things that we covered. And I'll tell you exactly the definition of negligent hiring. And negligent hiring is defined as an employer's failure to exercise reasonable caution when hiring an employee. Courts are increasingly holding employers financially and legally responsible for illegal or violent actions by employees who were not suitable and reasonable for employment. Now, the biggest thing in negligent hiring is what the employer knew or should have known. And right now, about 74%, employers lose about 74% of negligent hiring lawsuits. And the average lawsuit in negligent hiring that employers are involved in is $1.6 million.
And where does
A
that
single lawsuit?
A single lawsuit.
So
One
what
guy.
Are those?
Well, yeah.
Wow.
For negligent hiring.
What are those lawsuits? I mean, what are they?
Well, here, I'll give you some examples. I'll give you one in California. California jury awarded $12.5 million to on a negligent hiring case against a nursing home whose employee attempted to rape an elderly, mentally female patient. The company neglected to conduct their due diligence, and therefore hired this person and put him in a position that allowed him to rape this woman.
Okay, stop right there. Let's say I do a background check on this guy. He does not have any background that says I'm a convicted rapist or no criminal background at
Right.
all, but he still rapes her. How can I be liable for that?
You're not liable. Well, you're still going to be liable, but not under the negligent hiring law.
Okay.
Because the negligent hiring law is pretty direct in the sense that an attorney, all he has to prove is that the individual had the propensity.
Oh, come on now.
To commit
okay,
that
I
same
get that,
crime.
but how would I know or should have known that?
But if the individual didn't have a criminal record, you had no reason to take adverse
let's
action.
say
against
criminal
him.
record. Let's say I went to his house. Let's say I talked to his neighbors. Everybody said he's a great guy, and he turns out to be Ted Bundy. How much more due diligence can I do? I mean, I know I'm going to get sued, but
Right. You're going to get
I
sued
wasn't
for other
negligent,
reasons,
right.
but not for the negligent hiring. What we're discussing right now is what is the negligent hiring and how does that expose what exposure is that to an employee?
So not doing a background check, that's an easy one.
That's an easy
You're
one.
negligent.
You're
I don't care what
negligent.
anybody says. That's just, it's stupid, too, not to do a background check.
That's right. You didn't do it correctly, or you misreported the information, or you didn't use the information that was provided to you by a consumer reporting agency to deny that person a job.
Have they defined, number one, have they defined reasonable cautions? And number two, have they defined, if you're going to do a background check, what that background check should consist of?
Yeah, what's the standard?
The basic standard is you have to do a criminal search. Okay, every industry.
That's the minimum.
That's the minimum. Okay, every industry is different. Not everybody does DMVs. Not everybody does social tracers. Not everybody does sex offenders. Okay, these are different packages.
And they're easy to do, right?
And they're
Sex
easy to do,
offenders, I
'cause-
mean, you
Yeah.
can just do that yourself.
Basically, employers, the way employers are looking at it is that as long as I've attempted to do some kind of due diligence, and that due diligence for me as ABC employer is only to do a criminal search. Now, I don't agree with that because, say, for example, a sex offender. If you're a sex offender, okay, you may not have been convicted in that county and that state that you lived in, but you might have been convicted in Chicago, for example, and then moved to California. Well, if you don't check that sex offender registry, you've just failed to
Which they
conduct
don't,
due
right.
diligence.
Right.
And that's something that can affect any employment.
Any employment.
Any employment.
Any employment. That's why I always tell employers it's not that costly to
Yeah.
do a sex offender registry and to verify, because anybody that comes in as a registered sex offender from another state must re-register in the state that they're moving into.
Hold that thought. Fascinating information. We'll be back in a minute on Security Guy Radio. That's securityguyradio.com. Welcome back to Security Guy Radio. That's securityguyradio.com. Follow us on Facebook, Twitter, LinkedIn, and YouTube. It's kind of rolling off my lips now. Getting better and better, right?
Yes.
Yeah.
Very suave.
Chuck Carroll, Paul Bristow, and Mr. Rafael Jorge of RGI Investigations talking about background checks. All right, so we left the break talking about some negligent hiring, some case examples, and during the break you talked about one in New Jersey. How much was that for?
$40.6 million.
That's a lot of
A
money.
negligent hiring case. And again, was a nursing agency. I'm not saying anything against nursing agencies, but I'm realizing that there seems to be a pattern here where a lot of them are getting involved in some kind of negligent hiring suit.
So one employee who was, I don't know, what did the guy do?
I don't have the data on exactly what he did, but it did violate the FCRA it did fall under the negligent hiring doctrine, which obviously it made him unsuitable for that employment.
Yeah, he was hired.
He was hired.
And something came up that he did something wrong, and then one employee.
Big
Big lawsuit.
Now you have another one here out of California. It was a bus driver. Well, another nursing a bus driver, for a daycare health care center,
Oh, yeah. That's
driving
pretty bad.
elderly people around.
Yeah.
they found again negligent hiring, $850,000. So these cases are out there, and they're happening all the time. Negligent hiring is one of the largest the most prevalent lawsuits being filed right now against employers in all states.
So who gets it wrong when that happens? I'm the big corporation. I'm going to hire you, RJI, to do a background check.
Right.
And you come back to me and say, okay, everything's great. I got no convictions. We did a hand search in the courthouse. Everything's good.
Right.
But turns out you still missed something because Susie was out partying and something happened.
That's right.
Who's in trouble for that? Not me.
It's going to be the employer, and the employer then in turn is probably going to turn around and sue the background company. Because if I neglected to report a criminal record that I should have reported, okay, under, let's say, California, under my 7-year rule, and I did not provide you with that information, then the consumer reporting agency was negligent in that.
Okay, do you have insurance for that sort of thing? Not you personally, but companies have insurance,
They
right?
should have insurance.
So does that insurance indemnify and hold me harmless when I hire you for something?
Well, yes, in the sense that you're going to sue the consumer reporting agency for not reporting the criminal record that allowed you to hire Mr. Joe Blow, and Mr. Joe Blow then committed this heinous crime. You're going to get sued most likely by that Joe Blow's family, and then you're going to turn around and sue the background company.
So let's talk about California. Why is California so much more difficult, and why is it so different?
Well,
forms, paperwork.
Forms. And that is really the biggest violation right now going on in California. You have, like I stated earlier, you have the federal law, then you have the California law. Now, in California, we have what's called the California Civil Code 1786.22. It goes from like 0.9 to like 0.29. And these are all special provisions and policies that need to be in place when it comes to background forms in the state of California.
And these are forms that me as an employer must fill out, must maintain,
That's right.
must use.
That's right.
Okay.
That's right. And what it is that you have what's called the authorization and consent form. Okay, that's
so
basically.
Let's break this down for employment purposes. So I'm coming in, I'm Joe Smith, and I'm going to come get a job at a guard company, and you're the employer, and you're going to hand me this package of forms during the employment process.
Correct.
Okay.
Correct.
And the first form I need to fill out is what?
First you have the application.
Yeah.
Obviously,
Yeah.
and one of the biggest violation is that the background forms cannot be part of the application.
Oh, that's interesting.
They need to be standalone documents.
Okay.
You see a lot of applications out there for whatever reason they've never been changed over, whether it be cost or just not wanting to update their data.
Yeah,
but
yeah.
I have seen a lot of forms where the authorization for background is at the very last paragraph of the application, which is a no-no.
Yeah.
You cannot have that buried in the application. It needs to be a standalone document. Okay, that standalone document in the state of California, it is the consent and authorization form. And what you also need to have is you need to have the civil code, California Civil Code 1786, as part of that. Two of the biggest violations that I always see in this particular form.
Do you provide those forms?
Yeah, most
to your
consumer
people?
reporting agency, it's in my best interest to give it to my client
Give it to employers. Okay.
because I want to make sure that they're compliant.
Yeah.
And what does that
Okay.
form have on it? What is it?
Well, I'll tell you, two biggest violation I always see. It does not have the consumer reporting agency's information on that form.
Okay.
That's a violation.
Well, what is the form required to have? Kind of. What's the?
Yeah, and it's on the consent form. It needs to have the consumer reporting agency's name and number.
Right.
That is the company that's going to be conducting the background. It also needs to have in California a little box that says, "I wish to get a copy of my
I've seen
report."
that.
Oh, box. Yeah.
Now that is a huge problem because it needs to be all by itself
Yeah.
in its own
Okay.
little line. I've seen a lot of forms where it's actually buried in a paragraph, and it cannot be buried in a paragraph. It needs to be all by itself. It needs to be very, very clear and very visible for the employee to check that box.
So if it's not within compliance of that statute, you can get sued for that one little thing.
That's going to be an FTC violation.
Interesting.
And now you're talking some of these are can go up as high as $10,000
Per violation?
per violation.
Now, even if
employee.
they don't,
Per employee, per violation of form. So if you have, let's say, for example,
500 employees that are hired for a really big event,
okay, and there's a problem
and there's
with
not
the
500
background form.
boxes.
you got a
Wow.
problem. Even if they don't tick that box, if there's adverse action taken against them because of the report, they still have to
They
get
still
a,
have.
they
That's
still get
right.
a report,
That's right.
right?
That all
Yeah.
comes up. That all comes up later under the pre-adverse and adverse action letters. But in the beginning, if that individual checks that box that they must receive they want to receive a free copy of the report, the
They have to
employer
get a
must give them that. Once the consumer reporting agent gives it to the report, they need to provide that to them within 3 days.
Okay, so I come in, I get an application, I fill it out. You say, I like this guy, do an interview. Okay, now we're going to do a background check on you, and maybe make an offer contingent on your background check. I'm filling out a 1786.22 form. What else am I got to fill out? Required to, as the employer, to provide to the employee.
Well, the employer also should be providing what's called the consumer rights. Okay. The consumer rights is a form that has just been updated, and this is another major violation that I've seen a lot of times. And actually, Walmart was sued over $3 million because they were using the wrong consumer rights form.
Interesting.
Okay, so summary of consumer rights, and that is a form that needs to be given to that applicant once he fills that application.
And
out.
that just talks about the reporting agency's name, address, that kind of stuff,
It-
rights under the law.
Yeah, and it gives them the right to dispute the information. It gives them their rights. That's what's called the consumer report right, the consumer rights form, consumer of rights.
Okay, what else do we need for a form?
That's it. And that's
Those are the two major ones
those
to
are
do
the two
background
major
check.
ones.
Okay.
You
Now
need the
that
authorization
form
and
that they fill
consent.
out,
Excuse me?
that form that they fill out, are they supposed to get a copy of that?
I always tell the employers to give them a copy of that.
Doesn't
yeah,
hurt.
It doesn't hurt them to give them a copy. Yeah,
'Cause
and
I
then
know
give
some
them.
companies that do not give
And they do
copies
not
of
give that. And they do not give that. I've done consulting work for a lot of companies, and I see that they don't
Yeah.
do that. And there's a lot of little steps that they're supposed to be taking that they don't. And those are all major violations. And I'll tell you, the FTC, Federal Trade Commission, is really coming down hard on employers not complying with these forms.
Yeah.
Well, they
You
need
know,
money. They need that.
They need the
revenue.
money. You know what? California needs money. And if they could see that, FTC's got a watchdog group now that's looking out for these violations, and you start hitting employers up and down the state that are non-compliant with these forms, that's going to be a big issue, especially for the security companies. I mean, I've seen a lot of forms. I've done some consulting work, and I've seen forms that they're just not, in my opinion, they're not compliant. And all you need is one violation. And if you're employing hundreds of people and you've got that same violation, it is foreseeable that the FTC can come after you for every one of those forms and every one of those violations.
So I'm not an attorney. I've never played one on TV. Although I think I was Atticus Finch in a high school play once. But anyway, I read somewhere that these are not mutually exclusive remedies for employees to sue. In other words,
what does that mean?
it means if I sue you because you screwed up my background check and the FTC comes in and says, pay the money, the FTC can pick up the phone and call the unemployment department. They can come in and say, oh, that's a violation, pay the fine. They can call the other agencies in California and say, I'm sending you a violation notice, and you're going to pay a fine for violating those rights. So just because one agency fines you for it or you get sued for it by one agency or group doesn't mean you can't get sued by another one.
Yeah, and I mean, if you have
they're
other,
not mutually exclusive.
Right.
You can get sued 5 times by 5 different agencies.
yeah, and if you have a labor issue, the labor board
Can come in and say, well, what do you say? Well, but the FTC already collected money from me.
No,
That's too bad. We want our money now.
It could be a different violation.
And that's a big thing in California because California's so broke. It's a revenue generator. They want it.
As an employer, how do you make sure that you've got those papers correct? I mean, would a company like yourself come in and
they
actually
really should be
produce them
going out
for
to the
them?
consumer reporting agency that they're currently using and to verify that they actually have these current forms on file. Now, what I'm willing to offer your listeners, especially if they're security guard companies, they can call call me at my office, and I'd be more than happy to take a look at their forms at no charge to see whether or not they're compliant.
We'll put your number on a YouTube video. Put it
Yeah,
up there.
and I mean, if they want to take advantage of that, I'll take a look
What is your
at
number,
it.
just in case we've got somebody
It's
listening
1-800
right now?
Just in-
344
wait a minute. Just in case we have somebody listening. Is that what you said? There's 4,000 listeners.
So I
Say it
I
again.
just-
I'm sorry. Say it again.
It's 1-800-344-4754. And it's actually 344-4RJI. But really, I mean, these forms are very critical. And the last thing you want to be as an employer or a security guard company or whatever you may be is to be doing these backgrounds only to find out later that you could have avoided these penalties
Yeah.
if somebody had just taken the time to educate you and or to advise you as to the forms that you have. You look at an organization like Walmart that I just mentioned got sued over $3 million, right, for not having the proper forms. Now, you would think an organization of that magnitude has enough attorneys looking at their compliance
to keep up
issues.
to date.
And here's where I see the biggest problem. You have forms that are being created by corporations that may not, their headquarters, their home office, may be in a different state.
Yeah.
And they're using those forms that are compliant with that state, but not necessarily compliant with California, for example. Okay, I've seen that all the time.
Yeah.
Well, these were created by corporate. Well, they were created by corporate because corporate is located in, Tennessee.
And we know a company like that, correct?
Perhaps.
Yes.
So, I mean, and really, every state is different, and every state could and does have different form policies. And you just got to make sure that if you're employing in California, that your forms better be compliant with California law.
I've recommended clients in other states just use California. It's the highest standard. You
Well-
can't go wrong.
Yeah.
Right? Oh, there's the take a break music. We'll be back in a minute on Security Guy Radio. That's securityguyradio.com.
Now, this will be...
Welcome back to Security Guy Radio. That's securityguyradio.com. Follow us on Facebook, Twitter, LinkedIn, and YouTube. Back with Rafael Jorge. Wait a minute, I didn't roll my R.
You did.
Rafael
You rolled it quite a bit there.
Oh, did I? Okay, good. From RGI Investigations. Talking about background checks. We left off with two forms we just talked about, the 1786.22, and let's talk about the adverse action letter. Now, I need you to break this down and state it so that my brother in Oregon understands what you're talking about.
All right. So
What is an adverse action letter?
Okay. An adverse action letter is any information that is going to be used to take adverse action against an employee, meaning they're not going to hire that employee based on information that was obtained in their background.
So this is,
Okay.
I come in and I apply, and you do a background check on me, and I call you up and say, I can't hire you. I got to give this form out.
Right.
All right.
Well, you have to give what's called a pre-adverse notice. And this, again, one of the major violations in a lot of security companies that I have seen, they don't take time to send the pre-adverse letter and then the adverse letter. A pre-adverse letter basically states that, Mr. Harold, a background has been conducted, that may, it's the key word, may prohibit you for employment at our organization. The information was provided by, again, the Consumer Reporting Agency's information needs to be on that form, as well as their 800 number.
Oh, I get it. They do this so that the employee can go out and check on it, get
That's
some
right.
time to figure out what's going on.
That's
How
right.
quickly do you have to send it out? I mean, is
You
there
have
a
to send it out.
time?
You have to send it out immediately. Once I send you that the individual has a possible criminal record and or there is a criminal record that we're actually reporting as a positive on Chuck Harold, you as the employer need to send that pre-adverse letter out. What that pre-adverse
Is
letter
that within
does,
a day or
It's gotta be
is there
done
an
immediately.
actual
So-
stipulated time on it?
immediately, yeah.
Okay.
The FTC and the federal FCRA hasn't really taken a position on that.
Right.
But the bottom line is you need to send it out quickly. Now, the FTC and the FCRA have not taken a position as to how long you give that individual
To respond to it.
Oh,
to
that's
respond to it.
interesting.
Now, it says you must give them reasonable time. Well, reasonable time for me, what we do is 7 days, and this is what I tell my employers: 7 working days. Okay, that's reasonable time for Mr. Harold to review the criminal record. Okay, now the employer must send him a copy of the pre-adverse letter, and we provide you an example of that. You must also provide them a copy of the report that may be used against them, and you want to send them again the consumer rights form. Okay. Now, Mr. Harold has that opportunity to call the Consumer Reporting Agency and say, hey, you know what? I've got a problem. I'm disputing this information because the criminal record is inaccurate. It's not me, or whatever the case may be. Okay. If that information is not disputed by the applicant, then in a reasonable time, the employer then sends the adverse letter. So the adverse letter, the difference is it's final. It's a final decision. Based on the information obtained by the Consumer Reporting Agency, you are no longer eligible for employment
And the
And
employer
here are the reasons why.
produces that, right? The agency doesn't produce that; the employer does.
In some cases, some consumer reporting agencies do send that out for their
Yeah, I've
clients.
seen that. I've seen that
Yeah.
there was a service. Yeah.
Okay.
But that's critical, and I can almost guarantee you that very few security guard companies that I've dealt with, and that I have seen, and that I've done consulting work for, they don't do that.
No,
They don't,
yeah.
and a lot of employers, unfortunately. Now, as a consumer reporting agency, we have contracts on our clients that say that they will comply with these rules, and that's really the key thing.
So what happens? Most companies just say you're not hired.
You're not hired. I
And they
mean,
don't give
we
everybody
found
the
somebody
option
more
of arguing
suitable.
with it.
You know, and
Yeah.
the law is very clear in stating that it basically states if the information is used in whole or in part of to make a decision and to take adverse action, these things must take place.
So I think that's interesting. If you're going to do backgrounds, you better be ready to deal with it properly.
That's right.
If something
That's
bad
right.
comes back.
Again,
Yeah.
not sending out a pre-adverse
Yeah.
letter, that's a violation of the FCRA.
Yeah.
The FTC is going to come down on you for that, and that's easily a $10,000 violation.
Yeah.
So you know if they don't send out the pre-adverse, there's a likelihood they're not sending out the adverse letters.
Yeah.
A lot of employers, they just say, no, we found somebody more suitable. No, we're not going to hire you. Now, if the information used to deny that individual was based on that criminal record that was reported, and let's say that the applicant checked that box when I said earlier that I do want a free copy of my report, you better be prepared as an employer to provide them all that
Yeah.
information. Now, good luck trying to tell a client or an attorney or an applicant that you did not use the criminal record that
Yeah,
you're now
yeah,
having in
yeah,
your possession
Yeah.
to take adverse action.
Yeah.
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 Well, having said that, though, I definitely have found cases like we just talked about. When the guy lies on his application, the state of California still lets you fire people for lying. So it's
Yeah.
possible. But
Of course,
You
of
know,
course.
and
And again, he defrauded the application.
so,
You know,
I mean, anybody listening who's thinking, I don't think I will do background checks. It's too difficult. Don't think that way. All right. Do the background check. Just fill out the forms and do it properly. It's not that hard.
it's not
Once
hard.
you know what it is.
That's
the
right.
question is, what is it? And we
That's
have to
right.
find that today, I think.
That's right.
Yeah.
And I think the most important thing is for employers to associate themselves with a consumer reporting agency that is going to walk them through this
Yeah.
process.
Yeah, and when some big
Yeah.
box company tells you, "Oh, we're compliant with everybody and everything, and we're wonderful and everything's online," it's all a bunch of poppycock.
Well, you
and
wanna
Boulder
make-
Dash, and a couple other things.
You want to make sure that you are.
So let's talk about something the EEOC is doing. That's kind of scary.
Oh.
I've heard people tell me about this. I frankly couldn't believe it. I thought it was
Yeah.
a story from The Onion. If people know what that is.
I'll tell you.
Tell me what it is.
The EEOC, Equal Employment Opportunity Council, is
Oh, it's a council now. It's not a commission anymore.
well commission.
That's kind of scary.
I'll tell you, they would rather see criminal records not even being done for employment.
Well, I've heard that.
purpose.
That's right.
Okay, that's really the position they want to take. One of the strongest positions they're taking is in violation of Title VII. It was enacted back in I forget the year it was enacted, but you figure Title VII says you can't discriminate against a person because of race, religion, sex, origin, for employment purpose. Well, the EEOC is taking the position that because more blacks and Hispanics have criminal record,
I don't.
convicted
Hold
of
on one
criminal
second.
records.
I'm not sure that's true, Paul.
No, I've
Statistically,
No, I don't think it's. If you look at it, they have percentages of the general population, but Security Guy Radio does not condone that position.
I
I'm
think
gonna look that up.
other
Well,
races are,
that's fine. I'm telling you what I've read under the EEOC.
Oh, I know what they're saying.
Yeah, and
but
they're
I think
saying,
I think it's nonsense. But go ahead.
But
Yeah.
here's what they're saying. They're saying that because more blacks and Hispanics are being denied employment, okay, that it's a violation of Title VII. And what they're saying is, and basically what they want employers to do is to draw up a matrix system that says these types of crimes will be accepted in our employment. These types of crimes will not be
Oh, my
accepted
God.
Well, I
for
think that's
employment.
already there to a certain
Well,
extent.
it's
though,
you
isn't
know,
it?
and to a certain extent, it's always been there.
Yeah.
This is not a new thing, okay?
Yeah.
This is not something that just came out of nowhere. This has been going around. The problem is employers don't do it. What the EEOC is now wanting to do, and basically what they've done is they've done a policy guidance. It's not a law. It's just a policy guidance.
It will be soon enough.
It will be. I don't doubt that it will be,
Yeah.
And the EEOC wants employers, to take into consideration the conviction to the job that's being offered.
Yeah.
And that's something that employers should do anyways. Because,
Yeah.
really think
Yeah,
about
I
it.
mean, you gotta be
If the
fair,
guy's
right?
Yeah, if the
Established,
guy's
you
going to
know,
work for me
yeah.
as a clerk in my office
Yeah.
and he has a DUI, I don't see the relevance in that.
Yeah.
If he's going to be driving one of my company cars, there's obviously a
problem.
relevance.
Well, this
Yeah.
is interesting. 'Cause it's kind of like what Chief McDonald and Diaz were telling us about that. Kicking everybody out of the prisons because they're too full.
Right.
They've actually quasi-decriminalized some violations, so you don't even do time for
Yeah.
it.
Right.
They're just everything's
Yeah.
okay if you got a criminal. Kumbaya,
Yeah.
let's
Well,
roast
you look at
marshmallows.
the
We
whole
want
drug- you look at
not
the
hire
whole
anybody.
drug
Right.
issue.
Well,
Yeah.
I'll tell you
It
what the
is.
EEOC is really having a problem with is what they call a blanket policy. And a blanket policy is there are a lot of employers out there, especially the big employers, that if you have a criminal record, regardless of the nature of the record, you're not being hired in our organization.
Well, I think that's a good policy.
Well, that's a blanket policy. The EEOC is having a problem with that because they're saying, well, how
See,
relevant
I
is
would
that?
argue with that.
Well, I guess
you know.
it depends on the profession. I can't
Yeah.
have them in security.
It
Although some
depends.
companies would think you could.
Well, it depends on the crime. You
What's
know
the
what I
ban
mean?
the box campaign?
Oh,
Yeah,
ban
let's
the
get to
box.
this,
Let's
'cause
get to-
I've got
we
no
only got
idea
about
what
3
this
minutes.
is.
Okay,
First
3
thing
minutes.
I
I'll
do.
tell you. Ban the
Yeah.
box is another thing that's being pushed out by the EEOC. And the ban the box campaign is actually right now there are about 45 states and counties that an employer can no longer ask the question on an application, have you ever been convicted of a criminal record?
Now, is this a statute they're trying to pass? Or-
This is something that has already passed. As a matter of
Oh,
fact,
it's a law?
San Francisco is the only city in the state of California that is aptly and I believe San Joaquin is the other one, Stockton, that you employers as of August 2014, they will no longer be able to ask on the application, have you ever been convicted of a crime? What the EEOC's position is, they're saying a lot of people are being denied that job and they're not going through the due diligence or the proper process, and they're being eliminated based on this box.
Well, they normally ask you what it was. If you
Right.
tick the
In
box,
some
right,
cases
ask
they
you what it
do,
was.
but
Yeah.
the EEOC doesn't even want you to do that. And I know that this can go on, and
Rafael, what's your website?
we gotta go.
it's rgi.com, and anybody willing to take advantage of that opportunity to have your forms reevaluated,
Give us your phone number.
it's 1-800-344-4RJI.
Excellent.
great.
Excellent show. Very informative, once again.
Yes.
We
Stuff
always
I
learn
didn't know.
something ourselves.
Yes. Well, I always do.
Like
'cause
I always
know
say,
nothing.
here at Security Guy Radio, we protect you with with our voice because it's cheaper that way. We'll see you next week on Security Guy Radio. That's
Great.
SecurityGuyRadio.com. Follow us on Facebook, Twitter, LinkedIn, and YouTube. Good night.
Cheers.